Hi, thank you so much for joining our webinar today. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Mark Cobb, a Georgia construction lien law guru. Today's webinar topic is how to get the bonding company to pay. So without further ado, I'd like to introduce the fabulous Mark Cobb.
Hi, Jesse. Thank you very much for that very kind invitation. I think, gosh, I can't remember, this may be my 12th or 13th seminar with SunRay, so I really appreciate the confidence that you guys place in me. I guess we can go ahead and get started. Jesse, you may want to go over this, but I think if there's any questions, you want to put them in you want to send them in a message. Is that right?
Yes, absolutely. Just pose them in the chat for us and we'll answer them at the end.
Fantastic. Yeah. So today we're talking about how to get a bonding company to pay. And I have about 20 minutes to cover about 20 years of experience. And I have about 20 minutes to talk about something that I usually do a minimum of 50 minutes, often more like 90 minutes, because there's a lot to cover here. But I do want to start out with what is a payment bond and how do payment bonds really work. And the reason why I want to start there is if you don't understand the very basics, then actually making the claim can get very confusing very quickly. After we do the little preliminary, then I want to talk about the prerequisites for making a claim, because it's very important that you keep your claim rights. And then also finally, how do we make a claim? We're going to walk through the procedure for making a claim and what you can expect after a claim has been made. So first of all, the definition. What is a payment bond? A payment bond is a type of bond that guarantees that a contractor will pay the people below him. So it's very good for a lot of reasons. It's good for the owner, because the owner is less likely to have a project that has payment problems. It's very good for subcontractors, subcontractors, material suppliers, because if money is not flowed downstream to them, they have a second avenue. So if the GC withholds money that they should pay, if the GC files bankruptcy, if the GC absconds, there's lots of reasons why the GC may not be paying somebody. If they divert money to another project, then that subcontractor or supplier has a different option than just going against the contractor. They can go against the contractor, but they can also go against the payment bond. And the payment bond is a third party that's guaranteeing that payment. So when are payment bonds used? Well, in certain cases, they are required by law. Certain projects must have a payment bond attached to them. Other times, they're just simply required by the owner, or more often the lender. Again, they do protect the owner in this case, or as you can imagine, they also protect the lender to prevent payment problems. And so they're required. We see them on a lot of large-scale projects. So the four, sort of big global payment bond types are payment bonds on federal projects. They are required, and the law that governs this is the Federal Miller Act. You'll hear that bantered about. But the Federal Miller Act requires payment bonds on almost all, government projects, federal government projects. Georgia, and virtually, I think every single state has its own version of the Miller Act. In Georgia, it's called the Georgia Little Miller Act. The odd thing about Georgia is we actually have two separate Little Miller Acts. We have one that governs state of Georgia projects and one that governs Georgia county and city projects. So the county of Decatur, county of Fulton, county of Chatham, city of Savannah, city of Augusta, those are in a different statute than those required for the state of Georgia. So for purposes of this, the deadlines are the same and they're very similar, but there are some nuanced differences when you get into something more sophisticated. So you need to make sure that you understand that there is a difference. So if you have a claim against a school board, it's going to fall under the Georgia County and City projects. If it's against the University System Georgia, it's going to be a state of Georgia project. Both of those are required under Georgia's Little Miller Act, and they're on all projects of $100,000 or more. there has been a move in the Georgia legislature to try to increase that to $250,000. It did not pass this year, but I think a lot of us on the inside think that next year that threshold will increase from $100,000 to $250,000. The fourth type of payment bond are payment bonds on private projects. As I mentioned, owners may want them, lenders may want them. They're great to have. They're not required by law, so they may be governed differently. They're governed under a contract law. So whatever the payment bond says is how you make a claim. We see them a lot on large projects. I think virtually every Walmart that we've ever had a claim against has had a payment bond on it. Similarly, a lot of multifamily housing have payment bonds on it. So if you're supplying or working on a large project, it makes sense to say, hey, is there a payment bond covering me? It makes sense to do that up front, and it makes sense to try to get a copy of it if you can. So how do payment bonds really work? Well, it's important to know that payment bonds, there are three primary parties. And we use these big words, but it helps to know what they are. The principal is the first party. And the principal is usually, well, not usually, it is the party who obtains the bond. It is usually a GC or a subcontractor. An owner can do it, subcontractors can do it, but typically it's the GC or first tier sub. I'd like to point out that on large projects, you will often see more than one payment bond. Often the general contractor will have a payment bond covering everyone downstream or covering some people downstream. That GC may also require subcontractors to provide its own payment bond to cover those subcontractors and suppliers to that subcontractor. If this is the case, you have two separate payment bonds you can make a claim against and two separate principals, one being the GC and the other being the subcontractor. The second party is the obligee. That's the person really who's the ultimate beneficiary of a payment bond, and it's the owner. So on federal projects, it's the United States government, state of Georgia, or city of Valdosta, city of Rome. And on private projects, it's the owner. Could be Walmart, could be the owner of the multifamily complex. The third party is the surety. That's the actual guarantor of the bond. They're the ones who make sure that subcontractors get paid. The surety is almost always an insurance company, although they operate a little bit differently. And we see company names that you're familiar with in insurance. It's going to be Travelers, Fireman's Fund, CNA, Liberty Mutual, companies like that. If a claim is made against the payment bond, then that person is called the claimant. So I mentioned earlier that we have sureties here, and they are also insurance companies, but what's the difference? One thing that's important, if you think about a typical, say, maybe automobile insurance, if you have an accident, your insurance company steps up and pays for the damage to the automobiles involved. They may increase your premium, but you do not pay them back the amount that the insurance company has to spend to repair the cars or replace those automobiles. With suretyship, it's indemnification. So if a surety pays out on a payment bond, then the principal is obligated to repay the surety. This is a very important component in understanding how payment bonds work, because a general contractor isn't going to shrug his shoulders and say, oh, I don't have the money, go for my payment bond. Instead, that general contractor is saying, please don't go for my payment bond. If you make a claim against my payment bond, it could ding my credit rating. If they pay out, I'm going to have to reimburse them. And if lawyers are involved, I'm going to have to pay for the surety's attorney's fees. And you say, well, how do suretyships make sure they're going to get their money? Well, they do run very thorough credit backgrounds on the contractors. They also look at the size and scope of projects they have and assessing whether or not the project they're going to issue a payment bond on is one that this contractor should be able to handle. But they also get letters of credit, they get personal guarantees, and they take collateral. So if the payment bond has to pay out, they may write a check against that letter of credit, and the contractors just sits there owing, still owing the money. And it's important to understand this because it shows what the relationship is between the principal and the surety. So I think now we're going to talk about a couple of things you have to do to make sure you have a payment bond claim. And there's there are certainly several things, and the big one that's not on this one is document. Another big one that's not on here is each project has to be separate from other projects. So even if you're supplying to one subcontractor, they've got 6 different projects, you have to know where your materials are going and properly account for them. But the 2 big things I wanted to focus on today is, have you complied with Georgia's statutory notice requirements? So on federal projects, there is no statutory notice requirement. However, in the state of Georgia, there is. So if there's a payment bond and you want to make a claim against that payment bond, it doesn't matter whether it's a state of Georgia project, a municipal project, or a private project. If there's a payment bond and you work for a subcontractor or lower, then you must give a notice to owner and a notice to contractor. If you work directly for the GC, you do not have to do that. If you are a supplier to a subcontractor, you do not have to do it. But if you're 3rd tier or lower, then you must send out the notice. And I think SunRay does, and they do a lot, and we recommend clients use them. And this is a great service they provide. Another big sticking point is Georgia's lien waivers. So many people do not really understand Georgia's lien waivers. And we have made them complicated unnecessarily. So you can sign a lien waiver and it's conditioned upon payment for 89 days. That means if you sign it today and you say, oh, tomorrow, yeah, I need to get my money, otherwise I'm going to cancel the lien waiver. Or you can say, next week if I don't get paid, I'm going to cancel the lien waiver. You can set it up until 89 days. On the 90th day, that lien waiver then converts to an unconditional lien waiver. That means you can't void it. You can't cancel it. So if you have signed a lien waiver and you let it go for 89 days, you will be giving up your payment bond rights. Incidentally, you'll also be giving up your lien rights. So it's very important that you monitor the date that you execute a lien waiver. And if you need to void one, then you need to sign have an affidavit of non-payment filed in the county courthouse where the project is located. So now let's jump into the actual claim process. So before the claim is made, you really want to review a copy of the payment bond. I suggested earlier that you attempt to get a copy of the payment bond when you first begin working or first begin supplying materials to the project. The payment bond sets out who the surety is, who the principal is, who the obligee is. It sets out the notice requirements. And so it's a very important document to have if you can get your hands on it. You should be able to ask any of those 3 parties for it, and they should be able to give it to you. If the general contractor has filed a notice of commencement, it should have the surety's name in there. You can contact them. If it's a state of Georgia project, you can make a request for an open records and get a copy. There's several ways to get a copy of the payment bond, but it's so much better if you have a copy than just trying to guess. Another thing you want to assess, and I'd referenced this earlier too, is consider whether you will have one payment bond to go against or several. Similarly, you may also have lien rights. You do not have lien rights on a federal project. You don't have lien rights on a state of Georgia project, but on a private project, you may have a payment bond and you may have lien rights. And so if you take these last 2 statements, consider if there are other payment bonds and consider whether or not you have lien rights. I have seen before where a supplier has had a contract with an entity, they have a contract claim, they have a payment bond from the GC, they have a payment bond claim number 1. They then have a payment bond against their customer, also issued a payment bond, the subcontractor did, so they have a second payment bond claim. It's for multifamily housing, so they also have lien rights, and in the best case scenario, they also have a personal guarantee from the person or from the entity to whom they're supplying. That means you've got 5 pockets of money to go after. You can go after the GC's payment bond, you can go after the subcontractor's payment bond, you can go after the subcontractor directly, you can go after the contractors, whoever signed the personal guarantee, the owner of the subcontractor. That is what you want to see if you are working as a supplier or low tier sub. Incidentally, we do see occasionally personal guarantees, even in subcontracts. And if you're working for a GC or a subcontractor that maybe has questionable credit rating, it's something you might want to consider adding to your contracts. So look at all the payment sources. Don't just focus on the payment bond. Think about the contract rights, think about everything. You also want to review your contract and see what it says, because your contract gives you rights. Does it include, could you have different claims? So your contract claim, for example, may allow you to include attorney's fees. So on the slide, there's also the Prompt Payment Act. There's a federal Prompt Payment Act. There's also a state of Georgia Prompt Payment Act that may allow you to get interest, that may allow you to get attorney's fees. You want to know exactly what your rights are when you begin making your claim. You also want to gather all your documents. Documents are the most important thing. It's basically a numbers game. You want to be able to show you've got invoices, you've got delivery tickets, you've got daily logs that show you're on the project, you've got approvals from the higher tiers, approvals from the engineers, architects, or construction manager. All that goes to show that you did your work and you performed it properly. So you want to calculate the amount owed, and you want to be able to substantiate it with the proper documentation. So while you're waiting for that payment to come in, you've got work to do in case it doesn't come in. So that was before the claim was made. Now let's talk briefly about when the claim is made. No matter what, you must comply with the notice requirements in the payment bond. Most of the time, they're 90 days from the last day you worked. That's what the state of Georgia requires. That's also what the federal government requires. However, those are minimums. We occasionally see some surety coming in from another state, and their surety will allow 120 days. So you may have a little bit of time if the payment bond gives it to you. In other words, they cannot go below the 90 days that's required by law, but they can give you an additional time. And it does happen occasionally, important to know. Also, on private payment bonds, they're not governed by statute. So there's no minimum deadline. Typically, they run parallel. Typically, they're 90 days as well, but they could easily shorten that to 60 days or 45 days. So that's why having a payment bond is very important. When you read the payment bond, it will tell you to whom to send notice. And that's very important, because if you miss proper, if you don't notice the proper entities, you may lose your claim. It is almost always going to be the project owner, who is, of course, the obligee. It's going to be the general contractor, the principal, and it's going to be the surety. If we don't know who the surety is, if we don't know all the parties, we shotgun it. We send it to as many people as possible to make sure that we're going to meet their requirement to the best of our abilities. There's not an obligation to send in the backup documentation up front, but we recommend doing that. To me, it just shows that you're not being lazy and just, okay, we didn't get paid, now we're going to start a payment bond claim. We like to show that we put the work in to actually enforce our claim. Here are outstanding invoices, here are outstanding pay apps, here are lien waivers, whatever it may be, but we like to go ahead and show that up front and anticipate the surety, what the surety is going to want in order to make a decision. One key thing in your written notice, you must make a formal claim against the payment bond. There's no magic language, but you must state, we are making a payment bond claim. A claim is hereby made against the payment bond. And I actually use the phrase any and all payment bonds, because again, there may be more on the project that I'm not aware of. And then the next slide is sort of a quick version of what's going to happen after the claim is made. So most sureties that we deal with, I can't think where this hasn't happened, we'll get pretty quickly we get an acknowledgement of claim letter. By the way, when we send the written notice, hate to say this, but snail mail, I would never use that. You should use certified mail as a minimum, but the post office seems to be struggling right now, so we just do everything via FedEx or UPS or some other overnight carrier. That way we can more easily, more accurately track it. So we will get an acknowledgement of claim letter pretty quickly, and they do that to establish the right, the deadline, the date that the claim was received. In case it was tardy, they've got pretty clear course of business claim that we got on such a date. We always send the acknowledgement claim out the same day or the next day. Likely with the acknowledgement of claim, or subsequently you'll get something called a proof of claim. Sometimes it's just a letter saying we need these documents, and to be honest, they don't really look at what you've already sent. sometimes. So they may ask for the documents you've already sent. That's okay. We just photocopy them and resend them. It may be an actual form. Complete it thoroughly, because that's how that internal process begins working. They want to see the amount. They want to see a backup. They want to see the date you worked and backup. They want to see who you're working for. Let's see a copy of the contract. They want to see all of that. You'll receive an initial decision. And I'll be honest, 10, 15 years ago, we used to see probably 20% of the time, the initial decision would be like, you're right, the money's owed. These days, and I think because the sureties are taking more and more collateral from the principal, sureties tend to go to the principal, ask the principal why they didn't pay, and if there's any argument at all, they're going to deny the claim. Do not let that put you off. I mean, we're seeing, I think in the last 12 months, I've had one surety pay almost instantly, but everyone else, even the ones that should have paid, have been denied. So you'll get a denial letter, and then you want to respond to that denial letter. You want to provide backup documentation, additional evidence, perhaps photographs that show you actually performed the work. That's maybe when you get into daily logs or weekly meetings or what have you, but you want to be able to show that you did the work. Be careful with pay with paid, when paid provisions. These contract provisions, if it's a benefit to the principal, it can be a benefit to the surety. So if the principal has not been paid and you have a pay if paid provision that's enforceable, then the surety can say, we know you haven't been paid, but you're not supposed to be paid yet because our principal has not been paid. Remember to document, and review the payment bond. Sometimes we don't get a payment bond until after we've made the initial claim, but we always get a copy of the payment bond at some point early in the process. And you need to calendar the deadline to file the suit. It's usually 1 year. It could be 1 year from the date you last worked. It could be 1 year from the date that the CO was issued on the project. But you need to know the difference so that you don't let the claim lapse while you're waiting to negotiate it. So that is a super quick rundown, but I think we made it through in exactly 20 minutes. But I'm here for a few questions if anybody has anything.
Well, first of all, thank you so much, Mark. That really was great information. I know it was cram-packed full of little nuggets, so thank you so much for that. We do have a question that has come in so far. It says, if a bond isn't properly recorded, does that extend any of the deadlines?
Bonds are not recorded in Georgia.
Okay,
and so
perfect.
the deadlines would remain the same.
Okay, and then another question that has come through is, what mechanisms are out there to defend against paid when paid?
That's a complex question. It really depends upon the specific language contained in the contract. Before you even begin that fight, that's number one. Number two, I want to see what the GC is actually doing to actually try to get its money. I'd rather our client get their money months later than not get their money at all. So I want to work with the GC to try to do that. And then third, we are beginning to see courts get very frustrated with pay with paid. And my position on that is it's just simply not fair. The owners tend to have, oversimplification, owners tend to have the most money, GCs have the second most money, subcontractors can begin getting small, subcontractors get even smaller. And so what they're asking the lowest tiered person to do is take on the risk of the project. And judges are slowly coming around in certain states, not in Georgia yet, but in other states, they're beginning to slowly come around and say pay of pay just isn't fair. So we're hoping to see that in Georgia.
Okay. Another question that has just come through. I have a project and the GC has contractor default insurance, not payment performance bond. This is a federal project. What is and isn't the GC also required to have a payment bond for the benefit of suppliers?
I'm not exactly sure on the federal project whether that's substitute or not, and whether the contractor default insurance is a substitute for the payment bond requirement. Just haven't had to look into that. In Georgia, it is. And so the contractor default insurance is basically the similar claim. I mean, it's another pot of money that the general contractor has it's self-insurance basically, rather than going to an outside surety. And so they tend to operate very similarly to the payment bond claims. That's another topic. Maybe we can do that for a future seminar.
All right, great. We'll have to keep that in mind for sure. And then this one, it says, can you file a bond claim without having the full bond document, but you have the bond company and a bond number?
Unfortunately, we do that a lot. I wish
Yeah.
I wish I could always say that, but clients will call us and they may have 24 hours to get a payment bond claim out. So we do the best we can, and that's what we say. We're trying to shotgun it to as many different parties. We're going to look, see if there's a notice of commencement that's been filed that has that information. So yes, you can, and we've been successful with that too. To be honest, I mean, it's not the sort of the bottom line is this isn't a legal thing, but we try to make sure it goes to 2 of 3 people: the general contractor, the owner, and the surety. And so if we have any inkling, we try to do that. So even in a county situation, who do you serve as the county? We may serve every single member of the county commission. If it's a school board project, we may serve everybody on the school board and everybody in the county commission, not knowing who actually was the signator on the contract. So we shotgun it. We may send out 25 notices.
Okay. All right. Another question that has just come through. How would you defend against a contract review when the GC asks us to waive the Georgia Prompt Payment Act? Can you still sue even though we waived our right to, if there is a default in payment?
Yeah, I'm not sure you can waive that right in Georgia, but truthfully, and I hate to admit this, and I hope there are no GCs or owners on this conference call, but the Georgia Prompt Payment Act just does not have a lot of teeth. It's one of those ancillary claims we always throw out, but there's not a lot of teeth. So, I guess what I'm saying is if you waive it, it's probably not going to hurt you at all anyhow. But, I wouldn't waive it, but if you have to, I don't know if you can waive it legally. The big thing is your contract claim. That's the big number you're waiting on.
All right, well, thank you. I think that's all the questions that have come through so far. If somebody does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you.
Absolutely. My email is on the slide and you're welcome to email me or call me.
Yep, either reach out to Mark or myself and we'll be happy to make sure that we're getting the answer for you. All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead, scan the QR code, access these incredible resources, deadline calculators, project information sheets. It will be there just to help you remember to ask the pertinent information right at the start of your project, asking for those bonds, if there's a notice of commencement, whatever is happening to be going on, and get that information right up front, and it's always helpful. So check this out. There's a lot of information on this website for you guys. All right, our next webinar with Mark is going to be Don't Sign a Release Unless It Says This One Thing. That's going to be October 2nd. So go ahead and register for free at sunraynotice.com/education. We'd love to see you guys there. If you don't mind, take a brief moment to give us some feedback about the webinar. If you have other topics that you want us to be able to speak about, please let us know. We really do appreciate any of the feedback that you can give to us. All right, and here is Mark's information. Once again, I know that there was somebody who was asking for it, so please take note of it. If you have any questions, please reach out, let us know. And with that, that is all we have for you guys today. Thank you so much again to everybody who attended. We hope to see you guys at our next webinar. Mark, I can't say enough good things about you. You really are incredible. So thank you, thank you, thank you.
So thank you, Jesse.
Everyone has a beautiful and thanks. I hope you all have a beautiful and sunny day. Thanks again, everyone. Bye-bye.
Bye-bye.